Very good evening, everyone. Good evening, students. So, first of all, I welcome each one of you to my class on Code of Criminal Procedure 1973. Let's start with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen. Here is the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask your questions. At last, I have mentioned my code, students, that is Khatri10. You can use this code to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be interactive session. So the moment you feel you are not clear with anything, feel free to ask questions in the comments. So in this class, I'm going to talk about the two processes to compel the appearances of a person, and that is your summons and warrant. So when it comes to accused, you may send summons and warrant as well. So what is a summon? What is a warrant? What are the related provisions in relation to these concepts? We are going to discuss all these things one by one. So let's start with the summons first. So the first thing which you should know about the concept of summon is that it is one of the ways to which is basically a process to compel someone's appearances. Okay, and this is under chapter number 6 of CrPC. In chapter number 6, from section number 61 till section number 69 deals with the concept of summons. In relation to that, you can also add here the schedule 1 and form number 1, sorry, schedule 2, form number 1 as well. So there are two schedules in the CrPC. So the second schedule deals with total 56 forms. The form number 1 is basically your summons only, the formatting of summons. Any questions, students? Before starting this session, before starting this concept of summons, if you want to ask anything, feel free to ask in the comments. Okay. So the first three things which I have told you as of now is that it is chapter number 6, starting from section 61 to 69, and schedule 2, form 1 deals with the concept of summons. Now, what is a summon? For that, we need to enter into section 61. If you know the essentials of section 61, you can easily answer that what is a summon. The very first essential, every summon is issued by court. So who issued the summons under section 61? Can a police officer has power? The answer is no. So who can issue? The answer is court. The courts has the power to issue the summons. Under this code shall be in writing. The second important essential is it must be in the written form, which means that there is no concept of oral summons. It must be in written form only. So issued by court and in written form. Followed by third, it is always in duplicate. Now, why duplicate? Why do we need a duplicate summons? The thing is, students, that summon is kind of a request which is done by the court, that the person needs to present at this particular time in this particular court for this kind of a case. Okay. Why this is in duplicate? The person who is going to serve summons, one copy is going to be with the person only, okay, to whom the summons has been served. The second copy, for that the person is going to sign for the acknowledgement that he has received the summons. So that is why it must be in duplicate. The reason is that it will be used as an evidence in the court of law, that in a later stage, if the person is not present in the court, that he cannot take the defense that he was not aware about the concerned date and the timing when he needs to be present in the court. So that's why it must be in duplicate. Next one, signed by presiding officer. This is again one of the essential of the summon, that it must be signed by the presiding officer of such court or by such officer as the High Court may from time to time rule direct, and shall be a seal of the court. So these are the 5 essentials of summons. I'm repeating myself. First one, issued by court only. Okay, no other authority can issue summons under section 61. It must be in written form, so it cannot be oral. It will be in duplicate form for the evidence purpose that it has been delivered, signed by the presiding officer and seal of the court. Why signed by the presiding officer? Why sealed by the court? So that it can be confirmed that it is one of that valid summon that has been issued by the court only. So as per to section 61, these are the summons. Now coming to the second question attached to this concept is, why do we need the concept of summon? Because if the court wants someone to be in the court, that person needs to give the information, and to pass that information we use the concept of summons. So this is the basic meaning of the concept of summons. Moving forward, now the second question is, how summons served, or you can say, who is the one who actually served the summons? So section 62 answers that question. Let's read section 62. Every summons shall be served by a police officer or subject to such rules as the state government may make in this behalf, by an officer of the court issuing it or other public servant. So the answer may be, it may be a police officer or any other officer authorized by the state government or any other public servant. Now who is public servant here? That is your section 21 of your IPC. Okay, why we are entering into section 21 of IPC? Because of section 2Y of the CrPC. Okay, so this is basically your summons. Who is going to serve the summons? The summons shall, if practicable, be served personally on the person summoned. So the first priority, while the person is serving the summons, it should be served personally. So for example, if the summons is on the name of Mr. A, so those summons should be served to A only personally. That is the priority. But what if A is not present? What if you cannot find A? Then to whom you can serve the summons? Following with section 63 and 64. 64 and 65 basically answers that question, that what if A is not found? If after all due diligence you are still not found Mr. A. So if you need to found Mr. A, where you can find? His house, his office, or his place of business. Usually these are the places where you can find any person. But if after due diligence he has not been found, then those summons can be served to any family member. But what any family member? Only adult family member. And that adult family member does not include female members. And in addition to that, the servant will also not be considered as a family member. So if Mr. A cannot be found, you can serve summons to any adult male family member, and that does not include servant. Now, in addition to that, what if even the family members are not available? That can also be that can also be a situation where family members are also not available. Then what you can do? Then in those circumstances, what you can do is you can serve summons, and you can paste that on the door, which is basically any conspicuous part of the house or homestead. where anyone who is going to enter into that property can easily figure it out that yes, these summons have been pasted here. So this is your section 62 read with section 64 and section 65, that who is going to serve summon and how summons are going to be served. Sorry. Very good evening, Anu Yadav and everyone, those of you who have just joined. Moving forward, so we have just completed section 61, 62, 64 and 65. If you have any doubts, you may write your questions in the comments. Okay, moving forward. Now coming to section number 63. Before coming to section number 63, let's do a brief intro of this concept. When we say this term person, you can divide this concept into two parts. One is your natural persons. Second one is your juristic person, or you can say artificial person. Natural persons, your human beings. So how you can serve summons to the human beings? The answer lies in section number 62, 64 and 65. But what about if there is a juristic person? For example, in a case of a corporate body, societies. So, when we say corporate bodies, can they commit offense? And answer is yes. If you can recall the introduction question of IPC, that what are the essentials of crime, the very first essential is the term person, and section 11 person includes company corporations as well. So companies can also commit offenses only against property, not against body. Okay, so that's a minor point which you need to remember. Now in that situation, if we need to send summons to the corporate bodies, then the answer lies in section number 63. Now, for obvious reasons, corporate bodies are something which is a juristic person, not natural person. Then to whom the summons are going to be served? So the answer lies in section 63. So let's go quickly with section 63. Service of a summons on a corporation may be affected by serving it on secretary. So the first keyword, secretary, local manager or other principal officer of the corporation, or by letter sent by registered post. Address to the chief officer of the corporation. Chief officer here means the CEO, chief executive officer. In which the case the service shall be deemed to have been affected when the letter would arrive in ordinary course of post. So this is the way which you can use to send summons in case of corporate bodies, or you can say the registered societies. Moving forward to the next concept. What about in case of a government servant? So in case of government servant, section 66 answers that question. So that government servant, in whatever department he is working, there is going to be one head. So the summons are going to be served to this head, and that head will serve summons to the government servant. This is something which you can read from section 66. When the person summoned is in the active service of the government. Now, what do we mean by this term, active service of the government? So let's suppose if someone is already retired, then you cannot enforce section 66 because he is no more going into the office. So active service is one of the important essential. The court issuing the summons shall ordinarily send it in duplicate to the head of the office in which such person is employed, and such head shall thereupon cause the summons to be served in the manner by section 62. So what is section 62? That is personally to this government servant. So section 62, which means personally. 64, adult male member of the family. Section 65, conspicuous part of the house. So this is the procedure. So here section 62 also will play his role. Now coming to section 67, 68. 67 and 68 deals with the concept when you need to forward the summons outside the local limits, outside the local jurisdiction of the court. So that is, then in that case, whosoever magistrate is in that particular jurisdiction. So let's take one example for that. If this is the court, this is the jurisdiction of this court, court A. Now this court A wants to send summons to Mr. X, who is in the jurisdiction of court B. So the court A will send summons to the concerned magistrate, and that magistrate will forward the summons to Mr. X. This is going to happen if Mr. X is outside the local jurisdiction of court A. So now we can read section 67. When a court desires that a summon issued by it shall be served at any place outside its local jurisdiction, it shall ordinarily send such summons in duplicate to a magistrate within whose local jurisdiction the person summoned resides or to be there served. So that's why I have took this example. Section 68, proof of service in such cases and when serving some officer not present. When the summons issued by a court is served outside its local jurisdiction and in any case where the officer who has served a summons is not present at the hearing of a case, an affidavit. So whosoever, so let's take an example. If Mr. Y has forwarded that summons to Mr. X and he is not present in the court A, then what he can do is he can issue an affidavit with so and so that I have served the summons, and that affidavit will work as an evidence that the so and so summons has been successfully served. Section 69, service of summons on witnesses by post. So section 69 you can read with section number 62. Section 62 gives you three words. Who is going to serve the summons? The police officer, the officer appointed by the state government, or the public servant. But when it comes to section 69, you are sending summons by post. Why? Why there is a concept of post here and here police officer or a public servant or an officer appointed by state government? Because here you are talking about the accused and here we are talking about the witnesses. So this is the major difference. So this was your section 61 till section 69 about the concept of summons. Now anything you are not clear with or anything which is going into your mind in relation to the concept of summons, you may ask. Yes, please. All clear? The next concept is of warrant. And section number 70 till 81 deals with the concept of warrant. Section 70 is the most important, that tells you what is a warrant, what are the essentials of warrant. Okay. And usually when you got the questions in your mains examination, what is the difference between summons and warrant, then you have to basically compare section 61 and section 70, the essentials. Then you can also refer the schedule 2, form number 2. So form number 1 was in relation to the concept of summons. Form number 2 is in relations of warrant. So what are the essentials of warrant? Let's go into the details of section number 70. The very first essential, every warrant of arrest issued by a court. So who is going to issue the warrants? The court. Who was the one who was issued a summons? The answer was again court. It must be in writing. If you can recall, even in the case of summons, that also needs to be in writing. So there is no concept of oral summons or oral warrant. Signed by the presiding officer. So there must be signature. Just a second. Signed by the presiding officer of such court and shall bear seal of the court. Now there is one interesting question, students, here. You will find that the summons are also issued by the court. Summons are also must be in the written form. Summons also need to be signed by the presiding officer. Summon also needs to be the seal of the court. Then what is the major difference? The major difference is in the relation of duplicate. Now, why don't we need concept of duplicate and warrant? There are two reasons for that. Why there is no concept of duplicate warrant. The first reason is the police officer who is executing the warrant or any other person who has been taken who has been given the permission to execute the arrest, that police officer or any other person, but generally it's the police officer in 99% cases. So that police officer is going to basically arrest that person. So there is no need of acknowledgement that he has already received the summons, like in the cases of summons. So in this case, the arrest will take place. And the second reason, if not arrest, so what if in the cases of bailable warrant? If it is a non-bailable warrant, he will get arrested. If it is a bailable warrant, then there is always an option to give security of so and so, whatever has been written in the warrant, and he can be released. So that security only confirmed that he now knows that when he needs to be present in the court of law. So that is why there is no need of duplicacy of warrant. But in case of summons, that actually makes the sense. Moving forward, the clause 2 of section 70 is also important. Every such warrant shall remain in force until it is cancelled by the court. So what is the duration of the warrant? The duration of the warrant is basically, there is no time limit like 1 month or the 6 months or the 2 years. So the duration is until that has been cancelled by the court which has actually issued it, or it has been executed. So there can be only two circumstances when it got cancelled. The very first one is when it is issued, and the second one when it is executed. So cancelled by the court which has issued, or executed. Executed in a sense that he has been arrested. And cancelled is usually in also those cases when the person voluntarily surrenders before the court once he got to know that the so and so warrant has been issued on his name. So then also it can be cancelled. So that is your section number 70. Fabi, your आपका क्वेश्चन है सर, प्लीज रिपीट सेक्शन 67. Okay, I'm repeating section 67. Section 67 says, first let's understand the question that has been answered under section 67. The question says, if there is a court who wants to send summons to a person Mr. X, but the problem is this X is outside the jurisdiction of the court. Okay, so let's take an example. If this court is in Delhi and Mr. X is in, suppose, Punjab, so Mr. X is definitely outside the jurisdiction of the court. Now, how they can send summons to Mr. X? This is the question which has been answered in section 67. Now, what is the answer? The answer says that this court will forward the summons to the magistrate from the Punjab under whose jurisdiction X is living in. Okay, and then that magistrate will forward the summons to Mr. X. So this is not going to be directly to Mr. X. This is going to be through this magistrate. Not like this. Now you can read section 67. When a court desires that a summons issued by it shall be served at any place outside its local jurisdiction, okay, it shall ordinarily send such summons in duplicate to a magistrate. To magistrate, so I took the example of Punjab, so that is why magistrate from the Punjab, within whose local jurisdiction the person summoned resides. Okay, तो पंजाब में भी जैसे फॉर एग्जांपल इन जलंधर, okay, so the magistrate from the Jalandhar will be served those summons, and then the magistrate will forward that summons to Mr. X. I hope now it's clear. Section 67. Any other questions, students? चलिए जी. Now continuing with the concept of warrant. So section 71 you can read for bailable, what is bailable warrant, what is non-bailable warrant, what are the differences between the two. Then section 72 tells you warrants to whom directed, okay, who can execute the warrant. So it may be the police officer or any other person, okay, who has got the permission from the court. That person may execute the warrant. Section 75 basically deals with the duty of the police officer to show the substance of the warrant. You know, let's understand the concept of section 75 with an example. If this is the police officer and he's passing at the most famous dialogue that to Mr. A that you are under arrest, okay, then A may ask for that why you are arresting me, and then police officer may say I do have an arrest warrant on your name. Then A do have the right to see the warrant, the substance of the warrant, and police officer has the duty to show him the substance of the warrant. This is something which you can read from section 75 as well. Okay. 76 say once the person got arrested, without any delay, he must be presented before the judicial magistrate, that is under section 57. Then where this warrant may be executed, the warrant may be executed at any place within India, okay, but not outside India, because the moment you say outside India, for example, our neighboring countries like Sri Lanka, Nepal, Pakistan, Bangladesh, China, then there you cannot execute the warrants. Reason because there comes the rule of international laws. There comes the rule of central government. That there comes the role of the relationship between those two countries, and then there comes the concept of extradition and so on. Section 78, 79, 80, and 81 basically starting from section 78 till section 81 deals with the concept of if someone wants to execute warrant outside their local jurisdiction. So for example, in any another state, then yes, you may do so as suggested by section 77, that warrant may be executed in any place within India. But then there comes again a special procedure which you needs to follow. So this was your warrant and summons. Any questions, students? Now some important announcements I need to make. Let's crack PCSJ with Unacademy. From Feb 16 to 21, you can get 20% off on all the judiciary subscriptions. There is a free All India Judiciary Scholarship test that is on March 5th at 12 p.m. and rankers get a chance to win up to 100% scholarships. So make sure you don't miss that. Enroll yourself as soon as possible. You can use this barcode as well to reach out the concerned link. Unacademy is launching some of the batches. One is Safalta 4.0 comprehensive batch. This is going to be for 12 months. Already started from Feb 16th. Today only linking batch for RGS and JGS. This is your Rajasthan Judicial Services and Gujarat Judicial Services. The duration is of 6 months. Start date is today only, Feb 18. Then revision batch for UP mains exam, that is starting from Feb 23rd. Then if you are preparing for Chhattisgarh Judiciary, you can go for this prelims mock test series where you can get 5 full-length mock tests. These are the dates. If you are preparing for mains of Punjab Judiciary, then you can enroll yourself for this mains test series for Punjab Judiciary. Then one is your mains test series for UP Judiciary. And that's it from my end. See you in my next class. Till then, yes, it's time to say peace.